Continue. Anyway, I'm Ken Pryor, and I'm with Oregon Housing and Community Services. I'm here with my colleague, Judy Farrell, and Judy is going to assist us all in keeping track of where we're at in time. I've been told and reminded that the mind absorbs only what the posterior can endure. So Judy will make sure that we don't go on forever and we take a sufficient breaks now and then. There are a lot of things we're going to try to cover today. We're going to try to inform you on the available resources, particularly the website that we've had a lot of interest in it, but still there's a lack of visibility, and we're trying to get everyone oriented to the fact sheets and how that website works, and solicit feedback too as well. The only way it gets better is to get some feedback from yourselves. And you've actually, with this invitation, you also received another link to an evaluation. So you'll have to pull it up. It's a Microsoft format, but it's a very short evaluation of your perspective of things and things that you'd like to see covered. Today, we're going to address the rights and responsibility of tenants under Chapter 90. And again, your questions, we'll try to field them as time permits. If something gets too far into the weeds and specifics of an individual, we'll ask you to kind of hold off. We're trying to get through a little bit of a lengthy presentation and cover all the material. But if we should not cover something, certainly there's an opportunity for feedback, and we can have another Zoom meeting with you or with your park tenants committee or OSTA group. All that's possible. And with that, I'm going to start bringing up the website, not the website, but the slideshow. And hopefully this will become clear to everyone. So Judy, are you seeing the beginning of the slideshow? Hello.
Not yet, Ken.
I see it fine. Let's move it here. I think I have to share a screen. Okay, that should do it.
We got it.
Got it?
Yes.
Great, we're off and running. So there's, gosh, this is right in the middle of my viewing, this toolbar, but there it goes. So this is a short introduction of who we are, and actually the MMCRC in one form or another has been around since 1989, and our general objectives are to promote landlord-tenant relationships, be a central resource for referrals to different parts of state agencies, and to really encourage mediation, or what they may refer to as alternative dispute resolution. And for those of you that have any reservations, I want to remove any misconceptions about manufactured home parks. They're manufactured homes they're the only structures that are have construction regulations and manufacturing requirements. And the quality today is on par with any of the site-built homes that you have. All the amenities in a site-built home are available now in manufactured homes, and the parks are all over the state, not just rural counties. Parks and marinas are communities. People ride share, they grocery shop. They are communities unto themselves. And it's not a fad. Manufactured homes have been around since the 50s. And in fact, at one point in time, you could actually buy a home through Sears. They'd send you the plans and the materials full shot. And you're seeing that come back, I guess, in spades, you might say, with all the tiny housing and small homes that you see on the market today. That's kind of what it looked like in the 50s, and that was the sort of the American dream panacea. And you're going to see more of that with, I believe, with tiny homes, just because of the demand and the need for affordable housing.
Ken,
Yes.
Nancy wanted to know if they will have access to the slideshow presentation. They would like to share it with their mobile home community.
We can. We'll be able to send you copies of the slide, or send them to Deanna and let her, she's got a mailing list, or they can come directly here. But a copy will be available for OSTA and for anyone that requests it.
Great, thank you.
Sure. So just some basic, broad numbers. 10 million Americans live in affordable housing. In Oregon, there are almost 150,000 manufactured homes, 350,000 residents, basically. And we've got now responsibility with floating home marinas that account for approximately 1,100 floating homes and 3,400 residents. In Oregon, in total, there are almost 1,100 manufactured homes and slips, marinas throughout the states. And total representation in terms of population, it's estimated about 63,000 park spaces and slips. One of the other interesting things is that 30% of all manufactured homes or parks rather, are senior parks. And of those senior parks, half of them have residents are over 60, and 22% have children living with those residents. So it is a pretty broad spectrum of community, and a very important segment of the population. Ugly factor, since 1995, 73 parks have been closed. And in the last 20 years, though, only about 47, which would have counted for still almost 2,736 families, which is a lot of people. The parks are, again, just to give you an idea of the density, our largest park, I believe, is in Clackamas County, and it has something like 530 or so manufactured homes in the park. But you can see they're across the state in Coos County, Douglas County, Deschutes, Union County. There's some in Malheur County. So I've got a pretty good distribution of parks across the state. We're funded by the $10 personal property tax that you will see on your personal property assessment by the county every year. That $10 portion of it does go to the county. It's not all of our money, but we share that with the counties. We support the fair housing laws and support residents and landlords in understanding the vagaries, the ins and outs of those fair housing laws. And again, we're promoting mediation and communication skills training, and we have an 800 line support. And at the top is our 800 line number. It is extension 3. Our process really is to take the inquiry, research, response, and document. And a call can take from 5 to 50 minutes. Depends on the severity and the complexity of the call. Our website that we're doing a lot of work in now, the easiest way to find it is to Google Oregon, MMCRC. I don't want to give you a long, lengthy alphanumeric to remember, but Google is the easiest way to get to our website. It's Oregon, MMCRC, and that usually pops up right at the top, and you can go right into our website. The kinds of residents that we find in parks, you've got a sort of a mixed bag of tenants, and there are some that own their homes, some have caregivers, they have guests, some have temporary occupants. They also have tenants who rent a home from a park, which actually don't have the similar protections that residents of manufactured homes, but they do have rights in the park. But these are part of the community in which you live. And of course, we have some RV tenants that have, again, limited, don't have quite the rights as tenants that live in manufactured homes due to the federal regulation on manufacturing that differentiates a manufactured home from an RV or any other kind of structure that might be used for housing. In the parks, you got a mixed bag again of climate. There are managers that are hands-on or off, depending upon their idiosyncrasies and the size of the park. You may have a couple of managers. There's a change of park managers and ownership. You've seen that occur more recently in the last, I'd say, 2-3 years. Parks have been bought by venture capital funds, sovereign equity accounts, and you have various kinds of owners now. It's no longer mom and pop environment that initially I think people were more accustomed to. The rules can be very specific and restrictive, and sometimes even ignored. You're going to have more than one kind of rental agreement and set of park rules. Each individual in the park is bound by their specific rental agreement and their set of park rules that they signed up for. So you could have, depending upon comings and goings, you're very likely you're going to have more than one type of rental agreement in a park. And there have been specific laws created for parks. As the standard, we're looking at good cause evictions. Statutes have been enacted to provide some level of equity and security to tenants of parks. Parks have tenants committees, they have OSTA chapters. There are park closure laws in place that bestow rights on tenants. We'll talk about some of those rights later in the presentation. And also there's HOPA, which is Homeowners Protection Act, which is a federal law that allows for senior parts and instills a certain amount of specificity for senior parks and how they're populated. So to deal with all those types of climates and personalities and agencies, we have relationships with of course the landlords and their industry trade groups have MHCO, OPOA. Those are the two main landlord advocacy groups that we deal with. We deal with the your local community action agency for job training, energy assistance, and social services. That's where funding, we don't disperse any funds. All your funding for anything, food stamps, whatever, job training, energy assistance programs that are in place, they come from your local community action agencies. Again, we interface with OSTA. We interface with the all state agencies, and if you ask, we will tell you where to go to get those resources. There's fair housing, adult protective services, legal aid, building codes, DEQ. All those have responsibilities and serve your rights in one way or another in a manufactured home park. And of course, we work with the dispute resolution centers. Well, we call them community dispute resolution centers, and they're spread throughout the state. There are about 15 or so that we have relationships, and that's where we refer mediation. Those are a unbiased trained. Usually their training consists of at least 40 hours in mediation techniques. And they also do special projects. By special projects, what I mean is that if you're embarking on creating a tenants committee, there are rules in terms of how you run a meeting. They will come in and give you a tutoring on how to run a meeting and how to elect the officers, etc. And we will do the same as well, but these are folks that you want to get to know. They're in your local community, and they're your a real ally in the process of just maintaining your home and your rights, basically. So we look at ourselves again as sort of an information repository. You've got the 800 line, and again, more and more you're going to see our website, and that can be found again by Oregon, MMCRC on Google. That will always take you to our website. The website has a lot of different kinds of information and fact sheets. We're pushing it a little bit right now because we do suffer from a lack of visibility. And there are a lot of fact sheets and documents there that will answer a lot of your questions on parks and just exactly what your responsibilities are. To start off, let's look at the documents. I think everybody understands what a statement of policy is. It's not a part of the rental agreement, but it is sort of a if you can remember way back in yesteryear when you went to the movies, they always had preview of coming attractions. It's that kind of a document that is given to residents and potential residents that outlines the park history, They're, you know, uh, you know, they're, well, right now it's the um, utilities and the policies of the park, whether or not they're going to supply gas or electricity, uh, just exactly what those provisions are, whether or not the park is going to have uh, quiet hours, those kinds of things um, up front, sort of again, a preview of coming attractions, and you should be looking for that. And any new potential purchaser of a home is due a statement of policy and the rental agreement, and of course the park rules. But the policy statement of policy is something that's totally driven by the ownership. The rental agreement, likewise, it provides the location of your space, the size, the rent per month, and it will get into detail on the services that are provided. It talks about federal fair housing, age classifications, again, whether it's a senior park, any kind of improvements or conditions that the landlord uses in approving a purchaser of a manufactured dwelling or floating homes. And that's important that you remember that, because any previous or following purchaser of your home has got a baseline of what kinds of conditions the landlord can apply in approving that purchase. Park rules. This is a document that describes in further detail the regulations concerning the tenant's use and occupancy of the facilities. And it includes things like, hazard materials in your storage, yard maintenance, pet leash laws, a requirement, swimming pool access, vehicle speed limits. And park rules are a part of the rental agreement. And tenants do have participation in there is a whole process to modify or change park rules, which tenants can participate in. And with a 51% rejection on a petition, you can overrule any kind of a change suggested by park management. But it is the only document that tenants actually have input into, and that can be carried out. Usually it's done by petition. And one other thing that has come to fore, if there's a tenants committee or an OSTA chapter in a park, the ownership is obligated to provide a one-page summary of the tenants association, and the park or the tenants group of the OSTA chapter has to provide the landlord with that one-page summary. But what that does is it ensures visibility to any oncoming tenant that there is a tenants committee in existence, and lets people know it's a free advertisement, if you will, for your tenants committee or your OSTA chapter. And there's the specific chapter of chapter 90 there if you're really interested or need to understand it in further detail. So one of the things that you'll discover in looking at going through chapter 90, and it is a challenge to read, because there are things that on the surface don't seem to make they seem contradictory in terms of this section does not create a presumption that all rules and regulations are identical for all tenants at all times. What that means is that a tenant that is physically impaired, he can have a off-street parking, or a better example might be a wood pile. You can have one individual that takes care of the pile and it's neat, and another that things are strewn about and it's a hazard. Well, the landlord has the wherewithal to limit the amount of wood that an individual who doesn't show that responsibility, he can limit that or actually deny that if it's that serious. But I'm just showing this to point out that you have to read these things carefully and understand. And that's part of what we're here to do, is to help you understand some of these statutes that, frankly, aren't always as clear as we'd like them to be. So the HOPA Act, in terms of fair housing, that's the Housing for Older Persons Act. What that allows is that a senior park can be designated as a senior park and still have 20% of the population of be families. So this is the one area where a landlord could discriminate, basically, because he's got to maintain that 80% threshold of seniors in order to be a senior designated park. There are all kinds of accommodations, the reasonable accommodations that you can receive for a caregiver. Perhaps you need ramps, special parking, a rent payment date. Maybe your disability check comes at a certain point. You can have your landlord modify those payment dates by asking for a reasonable accommodation because you're receiving your payments on a certain date. And it also considers the kinds of service animals that you can have within the manufactured home park. Some of the rights are, particularly in a marina, 90.302 talks about the fees that are legitimate in a park or a marina. There are no parking fines in marinas. Non-compliance parking is not a rule. Basically, you cannot be fined for it in a marina. In a marina, there are no move-in fees. Those aren't part of the statute of fees that are permissible under statute. There aren't extra person fees. There are no overnight guest fees. And should the facility begin to make some improvements, perhaps could be as simple as stenciling the address on your sidewalk or whatever, and a contractor wants $5 from every home to clean up the sidewalk so he can print that address. Well, the tenants are not responsible for that contracted management fees. If the facility initiates that agreement, the facility has that responsibility. It's not passed down to tenants. Screening for marijuana use now is prohibited. In the state, I believe you're allowed a certain amount of plants that you can have growing in your backyard or whatever, but landlords cannot screen or ask that kind of questions in your approval process. Change in park rules. This is 90.610. You're going to need to understand that. Excuse me. It requires that process to change park rules. All tenants, all eligible voters must be notified. And that means the exclusion of people that live in RVs and or in a rented manufactured home. Excuse me. I had a cough all of a sudden. But the park management has to send these notices around that there's this change in the attempted change in park rules, identify the number of voters, identify the language of the changes, and has to identify the contact and delivery date for tenant feedback or tenant, usually it's a petition of approval or denial. And tenants have a 30-day window from the time they receive that notice to gather their petitions and make known their position. And if 51% reject the vote, then the rule change is denied. And all total, it's a 60-day process, because if petitions from residents aren't filed in another 30 days, the park rule change goes into place. So it doesn't require any action by tenants, but if you do so, it has to be within that 30-day window. Otherwise, in another 30-day, it becomes a park rule. So rent increases are limited to the 7% plus CPI that everyone is trying to wrestle with right now. No rent increases during the first year of residency. Tenants can use a realtor, and there is a fact sheet. It's a pretty long fact sheet, as a matter of fact, that you can find on our website, and it is a glossary of terms and things that you should know and your prospective buyer should know when you're going to sell a manufactured home or your floating home. And this is a document that landlords are to provide both buyer and seller at the time of a particular sale. So the document, again, is available on our website, and give it a look. It's pretty thorough. It's actually about 20 pages of information. And 590.530 talks about pets and facilities. You can exchange like for like. That means that if you have a Labrador Retriever and the dog dies within a certain amount of time, you can replace that dog, that Labrador Retriever, like for like. So a similar animal. It doesn't really cover if you've got a Chihuahua and then all of a sudden want to go for the German Shepherd. That's going to be kind of questionable. And in that pet agreement that you are going to be filling out, they'll have the leash requirements, noise abatement, cleanup, and it comes all rolled up into your pet agreement that you'll see. And they establish your rights for pets, and especially if you're considering service animals, you want to pay attention to that. 90.727 deals with hazard trees. And essentially, landlords are responsible for hazard trees, and that is defined as any tree that is greater than 8 inches in diameter. That's at breast height. That's what the DBH stands for. This diameter at breast height. .412 is the waiver termination. It's important to know that because basically, if a landlord accepts your rent for a minimum of 3 rental periods with the knowledge of maybe violation of some rule, perhaps. Maybe it is, say, parking on the street because you have handicapped guests that come and need to park close, and not in the park overflow lot. If he understands that and has that knowledge and doesn't enforce that, you can't go back and enforce that statute. So it's important to know, especially if you have a tenant, you have another party that resides in your home with you, and the landlord doesn't object to it, and he should have known that there's an extra party or parties that coincide with your residency. You can't come back later and say, "Oh no, you can't have those people residing," because after residing in the park for 3 rental periods, those people are actually legally tenants. They become tenants. So it's important to notice 90.412. And for 90.740, it displays information on what kind of obligations tenants have. And it's, general things like maintaining the space, being compliant with the rental agreement. And one of the more important aspects of 740 is that you behave in a manner that does not disturb the peaceful enjoyment of those around you. And the park is actually responsible for maintaining that peaceful enjoyment. And that could mean maybe you've got a neighbor that, has a loud radio or a loud truck or something of that nature, and he likes to start it at 2 o'clock in the morning because that's when he goes to work. There are limits that he can't excessively disturb your enjoyment and that of others in the park. And people can and have been evicted for that very fact. So peaceful enjoyment is an important right that you have within statute. The owner's responsibility, basically, we're talking about maintaining habitable conditions. And that encompasses, utilities in good working order, good drainage and operable sewage systems, maintaining the ground and the surface of the ground has to be safe for occupancy. We've seen older parks built on former lumber yards where the ground was compacted and was mostly sawdust. And ultimately, the landlord had to go back and stabilize the ground underneath some of these homes in a park, but they are responsible for maintaining a safe, habitable space. The landlords are responsible for keeping the park free of hazard trees. Again, that's that 8 inches in diameter at breast height. The glitch in that is basically, we'll cover it in more depth later, but typically, if it's on the tenant's property, the tenant may be responsible for bringing out a tree specialist or an arborist to declare the tree a hazard. But in overall, common areas are to be free of filth, debris, and vermin. That is the park's responsibility.
Yeah.
Yes.
I had a question about blowers.
Blowers. Well, that gets a little bit, it depends on, I guess, the amount of time that, there's that annoyance. And that's going to be, kind of user specific and what's your tolerance. As a matter of fact, I'm looking forward to my neighbor has a guy that does his yard, and they do it with a blower that could happen at any minute. And it's pretty darn noisy because he's across the street and I can still hear him. Yeah, and there's a reasonable way to approach that too. That's why you have mediation and dispute resolution. And every park has to have that kind of mediation policy written within the rental agreement to take care of some of these disputes that are invariable. A blower, again, I guess it depends on the length of time. And I think people are, part of the statute is founded on good faith from all parties. So there's got to be an element of compromise, I guess. That's to make everything to make things work in a park. You need that cooperation, and that's what it takes. Basically, is trying to coexist peacefully, so everyone enjoys that peaceful enjoyment that they sign up for. Ownership has a responsibility to provide you with the receipt, if you like. And statute 90.140, if you're interested, assures you of that right. Record keeping, landlords are responsible for keeping, maintaining a copy of your rental agreement. So if you've lost a copy, they should have a copy and be able to give you a copy of that. They can charge you up to, I think, 25 cents a page or whatever, but they are obligated by statute to have a copy of your rental agreement. Your rental agreement also covers how notices are served. And typically, they do what they call nail and mail rental agreement, where people nail something to your door. Usually it's masking tape or Scotch tape, and they send you a first-class letter. But again, that's going to vary from park to park and from individual to individual, depending upon what's outlined in your rental agreement. The same goes for storage agreements. And storage agreements are available. And when you're selling a home or in the process of selling a home, storage agreement basically secures the contents of the home. It authorizes visits. No one can occupy the house while it's in a storage agreement. The duration can be up to 6 months. I believe in a floating home environment that can be a year. And typically the fee for the storage agreement, it's equal to the rent. It can't exceed the rent. But it does permit authorization for tenants to come in and make improvements to the home, make repairs, whatever. But again, it's authorized and by appointment with your park. So the owner's responsibility, again, if there are violations, and there's a 30-day notice that's very typical that people will receive. And it's not some of the verbiage that's used in these notices tend to be a little bit severe and mention eviction, but landlords cannot evict you. They can terminate a rental agreement, but they don't evict you. They're given a 30-day notice, and essentially the process is after that 30 days, the landlord can file an FED with the court. You'll get a notice of first appearance, and you may get on that appearance court-directed mediation, which entails sometimes they have mediators And many of these courts, though they do not, you're kind of on your own with the landlord, or basically possibly an attorney. But should there not be any kind of a resolution through that brief mediation, there's a bench trial. And basically the bench trial, meaning the judge, is going to validate or not the termination of the rental agreement. So if it's not validated, the case is dismissed. If it's valid, there's a notice of restitution that's filed, and that can have various lengths of time depending upon the landlord. I've seen some of these notices that people were given 40 days basically to vacate. And then the other variable is the schedule of the sheriff. The sheriff is the person that actually executes the eviction. And depending upon their schedule, so there's some vagary there in terms of how much time a person would have to vacate. And again, it's driven by the park, what their requirements may be, and again by the physical actual schedule of the availability of the sheriff to implement. And another notice, it used to be a 72-hour notice that you would get. House Bill 2001 just recently was signed into law yesterday by Governor Kotek, and that 72 hours now is 10 days. So you have 10 days to comply or cure. And non-compliance, if you don't resolve those issues or whatever they are, not just rent, same process where the landlord files with an FED with the court, first appearance, court-directed mediation. You get the feeling of things. It's same process, but now you've got, rather than 72 hours, it's 10 days. So again, that's recent legislation, 10-day notice. Other notices that have occurred, recent changes in legislation. The procedure for facility purchase is 15 days. You have 15 days in which to contact usually the agency that you want to deal with is CASA, and they will assist you in developing and organizing a plan to make a bid to purchase the home. Should a landlord not provide you with those 15 days of attempting to make an offer, there's injunctive relief. You can actually stop the sales process, or worst case scenario, or best case scenario, I guess, for tenants would be a recovery of 10% of the sales price of the park if tenants have not been notified and given that right to purchase. And another new piece of legislation on floating homes, they have to give a 30-day written notice to a tenant in a floating home park if they're attempting to move that floating home for whatever reason. And the landlord has to move that floating home to a habitable slip, and afterwards he returns the floating home to the original slip. So those are important if you're living in a marina. 90.632 is termination for physical condition. And many of those are handed out during the, typically a park will do an annual inspection. The minimum cure time for any kind of a physical condition that they're looking to have you repair is 60 days plus extensions. So that would encompass things like if you can't schedule a workman or a plumber, if you're sick or ill, if the plumber or whatever doesn't have materials, you're entitled to extensions. And actual extensions can go up to as many as 8 months to repair in a manufactured home and a whole year in a floating home. And also 90.632 bumps up against another statute, 90.505, I believe. It excludes anything that is aesthetic or cosmetic. So just because the home looks dirty, maybe it needs power washing, or maybe it needs repainting. Those things can be kind of subjective, and you do have a right to contest those kinds of issues with your landlord. And even if you have problems, again, that may be a case for mediation.
And
Yes.
And I just want to ask, can a park specifically tell their tenants what color to paint their home?
If it's in the rental agreement, yes. And what they will do is that they will present you with a color palette. But if there's nothing in the rental agreement, it's, you know, they don't have a lot of authority to insist on you painting your home in another color. Again, that's something that's aesthetic, and typically they look for weathering of the materials of the siding, and whether or not something is going to lead to deterioration or not. Again, it's a bit subjective, but you have a right to contest those kinds of things. And just because the landlord thinks that you need a new roof, well, if you can show that you've had a roof repaired or within a reasonable amount of time, and assure that it's secure, you can contest those things.
Thank
And
you.
yeah. And again, the personal property notices that accompany every home in a park or in a marina. This again, the storage agreements for marinas are 12 months and 6-month storage agreements for manufactured home parks. And there are penalties that are associated with all of these particular rules if they're not followed, and you're not given your rights to establish, you know, adequate time to make those repair or have a reasonable storage agreement. One thing that has recently cropped up is the wording in the termination in the typical 30-day notice. They talk about things, and they use the term materially violates a law related to the tenant's conduct. So that's pretty broad. So that means a law, not just the park regulations. So, and it's materially means substantial, and theoretically people are supposed to look at the violation and put it in context in terms of maybe it's I don't know, smoking. Maybe there's a smoking ordinance, and before you would evict someone for smoking in places that are not smoking, you know, the seriousness of the violation has to really be calibrated in the context of the value of the rental agreement, your home and your well-being, as compared to what that violation is. If you're a continual storer of gasoline in your shed or whatever, there's certain amounts where that storage could actually become a violation, and parks are very sensitive to storage in sheds. But again, these things can be somewhat subjective, and materially comes into play now. So there's a little bit more flexibility afforded tenants now within that law. But it also encompasses people that are known drunk drivers. If the landlord should become aware of it, he could, and if it's a serious thing where it's chronic, he might find that need to terminate because there are too many children in the park. He could make that case. So it's not just your park rules and rental agreement, it's also the law in general now. There's also another facet to the termination, the 30-day notice, that you should be aware of, that the same act or omission of a prior violation, which reoccurs within 6 months, the landlord may terminate the tenancy upon 20 days written notice, and the tenant has no right to correct the second occurrence of the same violation. So you want to be very much aware of those things, and contest any kind of violation in writing whenever you receive something that you feel is abusive. And one of the things that is supposedly, well, it's a new statute, the notice of rights. And I spoke earlier about the fact sheet on buying and selling a manufactured home or a floating home. By statute, landlords are to present potential buyers and sellers with this informational handout. And it covers, again, rights of tenants and landlords, and things that you should understand when you're selling a manufactured or floating home. Gosh, excuse me. Again, it can be found on our website. And it's usually under the title of Learning More that you'll find these additional fact sheets and additional documents. Just a reminder that a landlord can't deny you the right to sell your home. He may not demand upgrade to current code. It just has to be safe and within code at the time that the home was established. And again, the purchaser must receive a statement of policy, rental agreement, park rules, and screening rules as well when they make an application. And the landlord must provide you a list of any improvements that he requires. All that has to be in writing. And after 7 days upon completion of an application, buyer and seller both have to be notified in writing. And failure to reject an applicant within 7 days, the landlord waives his right to establish new rental agreements, which means the new buyer can assume the existing rental agreement upon completion of the sale, and the new buyer may occupy the home and he assumes the previous owner's rental agreement. But again, taken with a grain of salt, it is based on providing a complete application and paying the application fee. But unless stipulated otherwise by yourself and the landlord, acceptance or rejection has to come within 7 days. On the outside, it could be 10 days if that's what you and the landlord agree to. And the other one of the common challenges are tenants committees, and tenants committees are created to discuss non-rent concerns, essentially. So there's no minimum number of people to create a tenants committee in statute. Reasonably, I would say at least 2 or 3 people. But that does not include residents of RVs or tenants who are renting their manufactured homes. The statute covers people that are residents and own their manufactured homes. You have to provide a park-wide notice of nominations and an election. You can count the ballots and notify tenants of the results. Then you announce your formation of the tenants committee or OSTA chapter in a letter to park management. In that letter, you request a meeting with park management. They have to respond within 30 days. All this is contained in 90.600. And you also include in that announcement a summary letter of your concerns, and it's sent to park management. And park management has to respond within 30 days, I believe. Statute assures tenants the peaceable assembly without infringement, meaning park managers can't attend, employees typically don't attend. There's a little bit of gray there in terms of whether or not a resident is also a maintenance guy, for instance. That might be an exception, but typically people who are under the employ of the park ownership have to guarantee your right for privacy. And that means communicating in assembly among yourselves. So you're assured some security there, not to be your privacy encroached upon. You're also able to canvass, post, publish, circulate, and distribute any matter relative to the Tenants Association or OSTA chapter. Those are your rights. One of the things that you should become familiar with and begin to teach your membership is that upon receiving a notice or a violation, respond to the landlord in writing, denying any such charge, and put in a phrase something to the effect of, these charges may not be used for any future action. And unless you deny these things in writing and things go to court, the allegations may be viewed as true because you haven't objected. So responding in writing and making them note that you're challenging the charges places the onus on the landlord to prove the violation. And then ultimately, you also may request mandatory mediation. And mandatory mediation now is a requirement that is in every rental agreement. So the dispute resolution, mandatory mediation, again, is in some form or whatever in your rental agreement, but there has to be that park mediation process, and the process can include informal dispute resolution. There's a demarc there between informal and mandatory now. Informal dispute resolution is totally voluntary, and tenant, upon tenant request, they can be anything from backing over someone's flowers, and again, there's a mediation center available to work those disputes out with tenants by a neutral third party at no charge. And then there's also mandatory mediation that's compelled. And defining what constitutes mandatory mediation is a little gray, but you can see how something that became, or initially was minor, can escalate, where it becomes at a point where it threatens someone's peaceful enjoyment or eviction. That's when you want to consider mandatory mediation. And again, mandatory mediation, we'll talk about it a little bit more. There are papers on the website that will give you information in terms of how to, negotiate, decide whether you want informal dispute resolution, which is voluntary, and mandatory mediation, which very often compels your landlord to participate in the park, in that mediation, because the park is the one that basically makes the laws and is required to enforce those park rules. And a mandatory mediation can be initiated by any party, including MMCRC. We can initiate it if requested. Typically, it's more meaningful if the tenant makes direct contact with the dispute resolution center. And the one thing about tenant-on-tenant mandatory mediation, it has to be initiated by the landlord. That's one checkpoint that keeps people aware of not escalating things unnecessarily, and keeping things that can be settled on the lowest possible level of activity, without overburdening people with petty issues. So you don't have the ability to actually require mandatory mediation with another tenant unless it's initiated by the landlord. Again, it compels parties to meet at least once. Again, either party can initiate mandatory mediation. You can contact ourselves, the CDRC, that's the Community Dispute Resolution Center, or a landlord. And the Dispute Resolution Center is tasked and in good faith schedule the mediation with both parties within 30 days. So you're permitted to have designated representation by an attorney or by another neighbor to accompany you, to give you additional support and give evidence. And the other important thing to notice about mandatory mediation it suspends any court action until mediation is complete. And the parties that enter mediation from the landlord side must be empowered to make decisions. So the things that you can't mediate are rent increases. Again, your tenants committees are formed to address non-rental issues. You can't mediate an unauthorized occupant, stalking or domestic violence. Non-payment of rent isn't mediation. Those things are pretty cut and dry. And any kind of a conduct that results in a 24-hour notice, which could be, a number of issues. Resolution is not guaranteed. Mediation, again, is conducted under the auspices of good faith, and people don't have to agree. You're just given that opportunity before other activities ensue. And next steps, if you don't have an agreement, you can obtain, there's a small claims worksheet that's again available on our website. And basically it will lead you through that small claims process. You can also contact lawyers referral service. It's a free service. Well, the referral is free. The actual consultation would cost you about $40, I believe, by an attorney. But those are resources, whether or not you want to take your issue to small claims, which does not permit attorneys. Basically, those are your options should you not reach an agreement. And if there is non-compliance where people refuse to mediate, there's a process where MCRC is notified, and actually a non-compliance letter will go out to the park ownership and any of the parties that were involved in the mediation. Overall, this is a bit of an eye chart. I know it's difficult, but the full flyer is available again on our website. And it leads you through the process of mediation and what your alternatives are. And this is just a bit of a teaser, not an eye chart for you, but it's there. There's actual documentation on the reverse side of the flyer that gives more information on mandatory mediation. And again, it's available on your website, our website rather. So the services that we provide, again, we're maintaining that directory, and you can go to a online directory that will show you whether or not your park manager was trained or not trained. Part of our services are education of the rights and responsibilities to landlords and tenants. We do registration and training, basically. We facilitate park meetings. As a matter of fact, if you would like the attendance of myself or another member of the MMCRC team, assuming that it's schedulable, we realize that some people are still adverse to meeting in large groups. Zoom is certainly a capability, but we can attend some of those park meetings if you're looking to establish, get some training wheels to help you get your meeting started. Obviously, that's part of the support that we provide resident tenants committees. We support mediation services, then we refer to other resources within the state that you may need. And one of the reasons why we're pressing on focusing on mediation is because of its unique problem solving environment where parties get to make their own decisions, and it's facilitated by a neutral third party that has no axe to grind. Again, these mediators go through some pretty extensive training, have a lot of experience, and they're there to assist you. They won't solve your problem, but they will assist you in getting your points across. But again, the ability to create your own solution is a big positive, because you don't have to adhere exactly to statute. If you go before a judge will adhere to statute. So there's some flexibility there that both landlords and tenants can enjoy. And again, it's interest-based problem solving. It's a new way of thinking, getting clarifying positions on what people want and what their interests are and why they want whatever it is that they're looking for. We promote your community dispute resolution centers because they have a local history of what's been going on, what they've seen in your locale. It's no cost to you or the landlords. Communication skills training. The CDRCs are available to do this under the heading of special projects. So they can come out and give you some conflict coaching or group facilitation. Again, those things are at no charge, but again, within the capabilities and the resources available in the Community Dispute Resolution Center. Some of the skills that they focus on are, listening skills, reflecting, speaking, focus on the problem, not people, and being forward looking, not going over past events and dwelling on them, but trying to look forward. They can counsel you in terms of effective speaking. Typically, people will take the approach of ready, fire, aim. But what the CDRC will kind of school you on and prepare you for is how to organize your thoughts and how to look at the audience and know what you want, identifying what those needs are, focusing on a problem, not the individual, and speaking in calm terms or tones rather, and especially to listen. Everyone wants their opinion heard. We're all pretty good at voicing our opinions and what we see as an issue, but listening is a little bit of a talent that's not always emphasized. One of the tools that they can teach you what is known as ACEs: acknowledge, clarify, emphasize, summarize. Those things build rapport, respect, and trust, and solutions. And listening, again, is a skill that not all of us are the best listeners, and it has to be cultivated. So the benefits of mediation, again, is that there are resolutions that you create, you along with the park manager. It also keeps the manager in a position of not taking sides, because again, that third neutral party is there to resolve issues. And you're going to gain a certain amount of skills and be able to solve problems much better, we've found in the future. Again, there's no charge for either party. So if you can do that, basically, all is right with the world. And if not, at least you've got hopefully mutual respect. So again, I'd like to remind you to take a look at our website, look at some of the fact sheets. Again, the best way to get there is through Googling Oregon, MMCRC will take you right to the web page. Lots of information and more is coming all the time. And if you got any further questions or issues that you want to discuss, happy to hear your issues now. So I'm going to stop the share.
Hi, my name's Pamela.
Yeah.
I'm in Brookings, and I really appreciate this. Has been very educational for me, so thank you. I want to backtrack to a couple of questions. We currently, our manufactured home park, a stream borders one side of the property. It affects about 15 units, and it's eroding. And the current park owner is putting it back on the resident, because we own our homes, but we rent the property to, build up with railroad ties or something to secure the property. I don't believe that's the correct answer, but I'm not quite sure who to go to present the owner with what agency to go to, or what company, in order to have them come and look at the erosion problem, because it's actually taking away the land all across these 15 units.
Well, that again, it's defined in 90.30, and the landlord is responsible for maintaining a habitable, space.
Mhm.
He's responsible for drainage, and any kind of erosion. He's basically responsible, because he's providing that space, and it's supposed to be habitable. You
Right.
might want to call county code enforcement.
Mhm.
And off the top of my head, I think there are some other institutions that are in the, I think it's in the Interior Department of the state government. But Pamela, if you send us a short note, I can give you a little bit more complete information on exactly the agencies that are responsible for maintaining proper lands. But typically, your planning board
Mhm.
within the county and code enforcement should be aware of that.
Right. Okay. We've had the owner out, and he's pushed it. He's put it back on. So I'm going to make what, we always, as you just mentioned, we want to create a peaceful situation. We don't want to be harassing, but it is important. And so I appreciate that. You mentioned early on, when you're talking about mediation, that you offer mediation training to tenants, or did I read
Well,
that?
it's we don't offer mediation training.
Okay.
If you're interested in becoming a mediator, your local dispute resolution center will certainly accommodate you. They're
Mhm.
looking for volunteers all the time. Typically, those programs run at least 40 hours, and they're done usually a couple times a year through the dispute resolution centers.
Right. All right. Well, thank you. I just want to again thank you. This is very informative, and I do hope that you'll be able to send this slide presentation, because for OSTA members that in our chapter that couldn't be here, I'd love them to see it as well.
Sure.
Okay, terrific. Thank you again.
Oh, you're very welcome.
Ken,
Yes.
Judy had a question earlier. She wanted to know wanted to get more clarification on landlord versus manager. Who needs to be trained?
Wait a second. Why did that pop up? Well, basically, anyone who has authority to make decisions in the park and is responsible for, implementing those park rules, those are the individuals that require training. Ownership, some of the smaller parks, owners are the managers. And so, the ownership does it. Typically, if you have an on-site manager, that person needs to be trained. But you can also have a park manager who is a property management company or just lives off-site, and he can or they can be trained. The statute is pretty broad in terms of identifying anyone that has authority to make those kinds of decisions within the park. Those are the individuals that require training. Sometimes some parks have several park managers or assistant park managers or trainers, yeah. And you can have multiple managers, or a park manager can cover multiple parks within reason. But it's the individual that has the power to make decisions relative to the park and enforcing the rules and, the habitability of the parks and maintenance of common areas, etc. The person that has that authority is the person that needs to be trained. And if that person resides in the park, that person is the one that needs training. Does that make it clearer?
Looks like Mike has his hand up. Thank you.
Yes, I'm not sure you'll be able or want to answer this question, Ken, but it's on the legislative front from SB 611, which proposes to rewrite the rent increases. I was hoping Angela would be here to possibly answer this, but anybody from OSTA, can you give us an update on the status of that? Is there any movement on it? And what are the possibilities of this becoming a reality? That's Senate Bill 611.
Hi, this is Pamela again. It was in committee yesterday for them to work on, and it's being stalled by two senators. And there's been a request to reach out to those two senators to ask them to move it forward. And I can give you, it's Senator Meek and Senator Solomon. Those are the two senators that we need to talk to and write to today.
Could you tell me those names again, please?
Yeah, I'm trying to find it in my I have a little hiccup on my iPhone right now, but it's Senator Meek, M-E-E-K, and Senator Solomon, S-A-L-L-M-A-N. I believe that's how it's spelled. And it's those two senators' office that's being asked to contact them, tell them how you feel, and ask them to please allow this to move forward. Personally, one of our issues are twofold from because we have a very active OSTA chapter, is that one, these organizations are putting us, all the advocacy organizations are putting manufactured homeowners or people who own their own home and rent the land into this huge tenant issue. And we're actually separate because we are homeowners. We're not apartment renters. And so part of it, I think we need to really be separated out so we can have address, especially at 55 and over who are on fixed income. So that's one issue. Second of all, there is a senator on the housing committee, Senator Ted Knopf, Knoph. He's on the housing committee, but he's also currently employed as executive director for the Central Oregon Building Association and an affordable housing developer currently. So he's receiving income from both of these organizations. So he has a conflict of interest. And I've asked him to please recuse himself because he can't be master to both organizations. He can't be master to the people of Oregon as well as to the landlords. And this is very defining, and it's not really been brought up into the public, but it's something that we all need to address because that's totally unfair. And the landlords have lobbyists that are going to the Senate to trying to get, this squashed. So we're anybody who can make those phone calls right now is critically important, and tell them your story, your personal story. They need to understand, especially for all of us who are on fixed incomes, the hardship that this is creating. Besides that, the Department of Oregon, who actually created this projection, their numbers are off because the inflation rate right now is under 14 point. The COLA, which is at 7% cost of living, and then the CPI is at 7.6. Well, the federal government CPI is at 6%, and they're projecting that this year it's going to go down between 2 and 4%. So the projection, the numbers are wrong. And so, it's this, there's some false issues here that are fallacies that have to be addressed in order to make the correction.
Thank you very much.
You're welcome.
Thanks, Pamela, because we're not allowed to make paid or unpaid political announcements.
Ken,
Yes.
I had a question from Nancy, and it's in the chat. It's saying our new managers told us last fall that they were going to rewrite the mobile home park rules and regulations. I asked one of the managers if homeowners could participate in making suggestions for any changes, and she responded no. Is she correct? To date, we have not received any changes to our rules and regulations.
Well, the thing that you need to be aware of is look for that notice. They have to notify you of any changes in park rules. And again, it's that 60-day process. You have 30 days to voice your opinion. You can make changes or give suggestions or not, or just you don't have to justify your decision. But usually people are more amenable if they've got some sort of a rationale to go by and they see that reflected in a petition. They're going to observe that. They have to stay within the statute, and they have to get 51% of the park residents to vote that way. Each home has a vote, and you have to complete that petition and deliver it, making yourself a copy, of course, to that person that they identify on their notice that you object. And if 51% reject it, it doesn't go into force. They cannot force it onto you. The only way that would occur is if people did nothing. If you don't do anything once it's been announced, in 60 days, it will become the park rules. So, maybe it was premature. Who knows where that is on their priority list? They'll get around to it whenever, but you need to be aware of the fact that it really is for you a 30-day process. You've got to let them know of your objections. You don't have to justify them. You just have to say you object, you reject, And 51% carries to the day. Simple enough.
On that same subject, can you request the ballot count and not who voted on what, but if it is a contested issue, could you request the ballot count and exactly what the yays and nays are from the management?
Well, I don't think you should know that because it's on the petition. There's no way, management doesn't really necessarily have to give you that information. You would know it through your petition. I mean, there's no real guarantee of their accuracy in reporting unless tenants know. And that's why it's best delivered through a petition. So you'll know how many people voted. You know how many eligible voters there are, and 51%, you know, I wouldn't count on them to give you necessarily the details.
We had an issue years back, and that reason I just thought of it, where one of the residents in the park presented it to the park management for rules change, and they brought it forward, and it didn't go through. But their explanation was, well, the vote was so close, we didn't want to institute it. And I thought that was kind of a wishy-washy explanation. And nobody requested a ballot count, or, you know, what were the yays and nays. But again, I thought that was a wishy-washy response.
Well, you got to understand, as a resident, you don't get to author changes in park rules. The authorization, the creation of those rules all come from management.
That's correct, but this came from a resident, and they suggested the change to park management, and the parks management brought it out. It was handled in the right manner.
Well, if the park put it out there and tenants, you know, approved of it, and then they decided that they weren't going to approve or enforce their own rule, I'm not quite understanding.
Well, no, the vote was so close that we just wanted an explanation. What were the yays and what were the nays, not who voted which way. And I don't think anybody requested it, but it was just a question in the back of everybody's mind.
Yeah. And again, the best way to understand that is to the fact that you're submitting that petition of rejection or approval. Once they introduce that possible change and it's approved by the it goes into effect, and they're responsible for implementing it. In terms of giving you actual numbers, again, they're relying on the tenants because that's where it's coming from. And you're better off. I mean, the ideal way is not everybody casting their ballot or their rejection as an individual. You have to do it really on a petition. So you know exactly, they identify the eligible voters to you. They identify the changes that they want to make. All that's in writing. Then your obligation is to respond in 30 days. Individually, you could do it, but how would you know whether it received yays or nay? I don't think there's anything in statute that says that they're obligated to give you that number. The onus really is on the tenants to understand what those votes are. And you'll know if it's a close vote.
Okay, thank you for the explanation.
Sure. So I hope that you guys will take the time to go online and give an evaluation of what you liked, what you want more of, what you didn't like. Because we have the ability to bring in other resources. Maybe next time it might be a legal aid attorney to address some more specific kinds of questions, if you will, or it could be a person from the Dispute Resolution Center to delve down more deeply into mediation. And I guess was it Paula? I will discover the appropriate CDRC and let them know you're interested in volunteering as a mediation. Yes. Yeah, that's where they get their mediators from. They're all volunteers, and they spend a considerable amount of time boning up on those skills. So we're getting close to our time. I don't know if there are any other outstanding questions. Just again, I want to encourage people to look at the website. We're trying to make it more user-friendly, and we need your input.
Ken, I do have a question.
Sure.
You and I have talked at different times over the years. First time I've had a chance to actually see you, Kathleen Lemke, Terrace Lake Park. We're just in the Salem area, large park. And I'm curious about the term that you use, a tenant association. We currently have a homeowners board, yet we're not a homeowners association.
Yeah.
And in fact, it's been great because I have seen a few other tenants on this call today, which is, more the merrier. The more we can learn, the better off we are.
Exactly.
But I guess I'm really curious as to what is appropriate, not being a true HOA. Are we more gathered together as a tenants association, and we should have a tenants committee that helps with activities? Because that's all we do. We have an on-site manager, which keeps things completely separated. So
yeah. Well, no, it really depends on, you're talking semantics now.
okay, right.
So you have a homeowners board, whatever, and it could be called a tenant association, but you'd have to formally notify the park that, this is what that association is, and show that you have created, you've had an election, you've sent out ballots, you've notified people. And then the reason why sometimes they call it a committee of 7 is because you're limited to the number of officers that will actually meet with the park management. And that is 7.
So there's a difference now again between a committee of 7, which we also have. So when you're talking about a tenants association, is that the committee of 7?
It could be. It depends on who's, well, here's the kind of the defining issues. A park only has to recognize one tenants association. And so it is the group that has given them notice, shown that they've had elections, shown that they've gone through the nomination process, and they've notified everybody. And in turn, once they've organized themselves, they announce that in the letter to the management of the park that, hey, we're here. We went through the process. We've established ourselves as, it could be whatever tenants committee or tenants association or whatever you want to call it. but we're officially notifying you that we are a group that's been organized to address non-rental issues
Okay.
in the park.
Got it. I understand.
And so, yeah. So, I mean, you can have, I mean, your board probably only has half a dozen or so, maybe 12 members at the most, but they want to make sure that it was grassroots creation, that there was a democratic process in creating that organization. And so, and that's where they draw power from. They don't have to meet with any other group if they don't want to. Only the one that they recognize. And if they're recognizing another group for activities or whatever, that's fine. But that group, they can ask questions, but management doesn't have to respond. Management has to respond and meet with the tenants committee at least once a year.
Okay. I do see the distinction. Thank you very much.
Sure.
Ken, Kathy has a question.
Okay.
Kathy, you just need to unmute. Hang on, I'll do it.
I got it.
Okay, cool.
Can you hear me now?
Yes.
Our question here in our park is, can a manager incur a $50 late fee for a late rental payment
5 days.
of 5 days?
Well, in your rental agreement, it spells out exactly when rents are due.
Yes.
And typically on the 5th day, if you haven't paid your rent, you're going to get that late fee.
So that's legal.
That is legal.
Okay.
However, if your Social Security check or something, your disability, whatever, comes in, say, on the 9th, you can ask for a reasonable accommodation because of that. And they should be able to adjust, your rent date, appropriately.
Okay. Thank you very much.
Sure.
Ken.
So the question from Judy.
Holly Bell has a question. If a community manager has an open door policy, what are the benefits of a tenants association? It sounds like it could limit the ability for residents to go directly to management.
Well, the tenants committee does not exclude any member of going directly to management. They always have that right.
Mhm.
But what you'll find is that there's strength in number. And if you're having a problem, chances are somebody in the park as well has that same problem. And it's okay to go individual, but you're relying on the park management then to aggregate all those issues and do something with them. If you go through a tenants committee, you've done that filtering process already. And now you've got the power of the tenants committee and all this membership making that recommendation. So it's strength in numbers kind of a thing. And some managers are very good at it, and some others are not. Okay. Big Valley Woods. Oh, that's out in Boring, I think, that area.
I just wanted to let you know, Ken, it's 11:55. We got 5 minutes left of the meeting.
Okay, well, if there's no other, you
Can
know
I-
how to get a hold of us. You can, again, jump online and we're going to send out a copy of the presentation to Deanna. We don't have, I guess might be able to pull it from the chat, but she's got a better connection to you guys than we do, I think. But in any case, we'll get out a copy of the presentation.
Kathy, did you have another question?
Yes, can you hear me?
Yes.
Okay, can we ask if our management has been trained? If our manager has been trained?
You can, and you can see it again on a one of the directories for your park, and it will show the individual that has been trained or not.
So how do we go to the directory for our park?
Everything's on the website.
Oh, yeah, okay,
Or just call us. If you got an email address, I'll send you a link.
okay, I do have
find
an
it.
email address.
Okay.
It's K.R. Hensman, HENSMAN @gmail.com.
K.R. Hensman, H-I.
HENSMAN, Hensman.
Oh, Kinsman. All right.
It's K.R. Hensman, KRHENSMAN @gmail.com.
Okay. All righty.
Thank you. That would be great.
So with that, I wish everyone a
Good day.
good day and hope to hear from you soon, and try to find that link and give us some feedback.
Good, will do.
Thanks so much.
Okay.
All right. Bye-bye.